This conference will now be recorded.
Welcome to DRTSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello, and a warm welcome to the senior lawyer, I should say, Mr. V. Sudhish Pai from Bengaluru. Let me just give a brief about him once again because this is the second time he is participating in our shows. Once this is done, I need not introduce him again, time and again, as and when he happens. And I'm very kind enough to host him once again on an important matter which is should have been very constitutional, all adhering to the basic structure of constitution. The Election Commission of India holds elections across India, whether right from Panchayat to the Lok Sabha. Panchayat and other local bodies are taken care of by the State Election Commission. Then, under the Election Commission of India, Commission of India, the state electoral officers do conduct elections. So that is how we have people participatory, constituent democracy, wherein we are represented by our representatives, which whom we elect to the assemblies and Lok Sabha. We call them as lawmakers. They make laws. How do they make laws? Out of our demands, whether it is welfare or development. I say the citizens, the citizens conditions irrespective of creed, caste, creed, or religion or region, they are taken care of vis-a-vis natural resources to administer them in a transparent and accountable way. We elect them, they make laws, and those are implemented by the IAS, IPS, IRS, those who have been selected on the basis of all India examinations and the local state examinations respectively. This is how the system works. And then we have the another set. Even the president, honorable president of India, is first citizen elected by those constituent assemblies whom we have already elected, and from the Lok Sabha they elect the president, and president in turn appoints the governors to the respective states. And I need not go when I have such a constitutional wizard quoting this article or that article. We will hear from him. This is the setup. An elected government is in place. Then the president appointed governors. What are their duties? And what are the constitutional obligations of those elected representatives vis-a-vis basic structure of constitution? Why this tussle, which has been happening in every state? Me and Sudhish Pai ji garu, we were discussing last 4 5 months back when the tussle happened in Kerala, then Tamil Nadu, and then when Telangana was happening. But he was traveling, he was literally busy, so we could not host. But now this show is of paramount importance when it comes to the center and state relations. We say center, again the Council of Ministers who advise the president. Similarly, the state Council of Ministers who advise the governor. Why this tussle in between the governor as well as the state, as is happening in Delhi, then Maharashtra subsequently will come later, and all other states in India, forgetting that they are bound by the constitution in principle, and the people are the citizens of India themselves are the constitutional authority, right from Prime Minister to Chief Minister. They're all public servants, including IAS, IPS. Instead of giving due diligent service in a transparent and accountable way, why this tussle between governor and the elected government? So that is what we are going to take up. And let me just give you a brief of Sudhish Pai ji. He is a senior advocate, is a distinguished lawyer and jurist, and an acclaimed author specializing in constitutional law and administrative law. Having obtained a master's in mathematics and a degree in law with the highest marks in the university in constitutional law and administrative law, he started the general practice of law about 38 years ago, joining the chambers of the Doyen of the Bar, late Sri S.G. Sundaraswamy, renowned senior advocate and former Advocate General Karnataka. His law practice covers different branches of law, mainly civil, constitutional, administrative. He was also government advocate, High Court of Karnataka 1999 to 2006, and handled important and sensitive litigation on behalf of the state. Apart from private clientele, he has appeared for and advised various institutions. He is a member of the Indian Law Institute, New Delhi, and Karnataka, India section of International Commission of Jurists. Assisted with he assisted Dr. Durgadas Basu, the world-renowned commentator on constitutional law, in the revision of his commentary on the Constitution of India from 1993 till Dr. Basu's passing away in 1997. He is a contributor to the restatement of Indian law on legislative privileges. That is why this show is more important for everyone to understand. He is that experience, such encyclopedia when it comes to the legislative affairs. A project of the Supreme Court. That legislative privileges was the project of Supreme Court. He was visiting chair Professor Asutosh Mukherjee chair at the West Bengal National University of Judicial Sciences, Juridical, Judici- how do I spell this, sir? Juridical, Juridical. Okay.
Critical.
Juridical Sciences, Kolkata. He is a resource person at the National Judicial Academy, Bhopal, for continuing legal education for judges. And he is associated with the Law Commission of Karnataka as senior research scholar. He has participated in several seminars across, and his contributions are very much there even in the Indian Express. His works include Legends in Law, Our Great Forebears 2012, Working on the Constitution, Checks and Balances 2014, The Judicial World of a Multi-Splendid Genius, Sir Ashutosh Mukherjee, and Sir Ashutosh Mukherjee's Judicial World Through Judgments, 2 volumes in 2014 and 15, A Judge Non-Parallel, a B.K. Mukherjee Reader 2016, then Constitutional Supremacy, a revisit essays on constitutionalism, rule of law, and constitutional adjudication 2019. Justice M.N. Venkatachalaya, The Man and the Judge, a Venkatachalaya Reader 2021. And I'm privileged because he allowed me to host such wonderful show where all the Chief Justices, incumbent, the present, and the former Chief Justices, including a lot of legal luminaries, were part of such show. And we are privileged, DRTSPR channels, to hold that show, the latest of his writings, that is Soli Sorabji, A Great Maestro 2022. He is also the present revising editor of the classic work V.G. Ramachandran, Laws of Writs, and so on and so forth. And he has received many awards. Scotch Award for Exemplary Service to Law, The Man and the Judge. And then, uh, to quote from Chief Justice Venkatachalaya's forward to Sri Pai's book, Constitutional Supremacy, a Revisit, Sir took upon himself, that's how he is fondly called as, Sir White took upon himself this enormous task of educating the schoolmen of the spirit of constitutionalism. Sir White's work is monumental. Sudhish Pai, an accomplished lawyer and jurist, belongs to the same distinguished class. He also refers to Sri Pai as a legal philosopher. And to repeat what Chief Justice Chittatosh Mukherjee said, Professor Atia, in his 1987 Hamlin lecture, speaks of the complementary role of judges and academics in the development of the law, and says that while judges are engaged in the often very pragmatic business of deciding cases, it is scholars who are primarily responsible for the part played by reason and theory in the law. In this connection, the role and contribution of Sudhish Pai, a distinguished scholar, has been laudable. As Professor Upendra Bakshi remarked, Sri Sudhish Pai has pursued and perfected the art of judicial biographies, and in so doing, he has accentuated the true meaning of the bar as a learned profession. Thank you very, very much once again to host you such a wonderful personality. Sir, straight away, because this introduction is very much important for this topic. How do you look at this scenario, sir? I will play some videos, but after your first introduction only, in between I will show how this is again has become a political rhetoric. Such an important
Let me
judgment.
complete it.
Yes, sir. Please go ahead.
Good evening. This The presentation has arisen. I have been invited in the background of yesterday's Constitution Bench judgment in the Delhi case, but that requires us to see the whole issue in a larger perspective, and that is the form of government. which the Constitution envisages and has adopted, namely the cabinet form of representative democratic government, which is tersely described as the Westminster model, where the real power vests in the Council of Ministers, the head of state being only a ceremonial head. Elucidating the essence and nuances of this, Chief Justice B.K. Mukherjee, almost at the very beginning in 1954-55, in Ram Javaya's case, said, "Our constitution, though federal in structure, is modelled on the British parliamentary system. The president is the formal or constitutional head of the executive. The real executive powers are vested in the ministry. We have the same system of parliamentary executive, and the Council of Ministers, consisting as it does of members of the legislature, is the cabinet, which, like the British cabinet, is a hyphen which joins, a buckle which fastens the legislative part to the executive. The cabinet, enjoying as it does the majority in the legislature, concentrates in itself the virtual control of both legislative and executive functions. As the ministers constituting the cabinet are presumably agreed on fundamentals and act on the principle of collective responsibility, the most important questions of policy are formulated there." Now, moving the draft constitution, Dr. Ambedkar posed the question, what is the form of government that is envisaged in the constitution? And he proceeded to say, "There is placed at the head of the Indian Union a functionary who is called the President. The title remains one of the President of the United States, but beyond identity of names, there is nothing in common between the form of government prevalent in America and the form proposed under the draft constitution. The American form is the presidential system. What the draft constitution proposes is the parliamentary system. The two are fundamentally different. Under the draft constitution, the president occupies the same position as the king under the English constitution. Is the head of state, not of the executive. He represents the nation, but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. The President of the Indian Union will generally be bound by the advice of his ministers. He can do nothing contrary to their advice, nor can he do anything without their advice." Now, all this has been very succinctly referred to, quoted, reiterated almost 50 years ago in the leading case of Shamsher Singh versus State of Punjab. In that, Justice Krishna Iyer, in his inimitable style, posed the question, is the Rashtrapati Bhavan a halfway house between Buckingham Palace and the White House? And he proceeded to answer, again in his very picturesque language, "Not the Potomac, but the Thames fertilizes the flow of the Yamuna," if we were to use a riverine imagery. Now, this captures the entire system of government that the Constitution envisages. The court unequivocally reiterated the settled legal position that the president or the governor, the governor in the states is of the same position, except that there is a slight difference. Article 163 makes a slight distinction in the position of a governor, that he is not bound by the advice of the ministers in matters where he is by or under the Constitution to act in his discretion, not otherwise. And that discretionary power is is restricted by the express language of 163. There is no general discretionary. The position of the president or the governor is only the constitutional head, the real power being in the Council of Ministers, on whose aid and advice the president or the governor exercises his powers and functions. the satisfaction required by the Constitution is not the personal satisfaction of the President or the Governor, but the satisfaction of the President or the Governor in the constitutional sense in the cabinet system of government, and that is the satisfaction of the Council of Ministers. In constitutional law, the functions of the President and the Governor and the business of government belong to ministers, not to the head of state. Aid and advice are terms of art, which in law mean, in the cabinet context of our constitutional scheme, that the aider acts and the advisor decides in his own authority, not subject to the power of the president to accept or reject such action or decision, except in case of governors, to the limited extent that 163 permits, and being remote controlled by the union. The omnipotence of the president, and this is again Subshir Singh, of the governor at the state level is euphemistically inscribed in the pages of fundamental law with the obvious intent that even where express conferment of power and functions is written into the articles, such business has to be disposed of decisively by the ministry, answerable to the legislature, and through it vicariously to the people, thus vindicating our democracy instead of surrendering it to a single summit soul whose deification is incompatible with the basis of our political architecture. Now, this very clearly underscores the ideas of representation and responsibility, which are the twin attributes of a parliamentary system. I think this summarizes the position of the, very broadly, the position of the form of government and what the Constitution envisages. Now, the Constitution, as we know, sets up a federal form, a federal polity. Well, it's not a federation in the strict classical sense, but the most important and perhaps indispensable attribute of federalism is that there is a division of power between the union, the center, and the federating units, call them states, provinces, whatever name. And that is done not by any law, but by the Constitution itself. And going by that test, which is universally accepted, though there are very different forms of federalism throughout the world, and no two federations are similar. Going by these tests, India is a federal polity, of course, with a drift towards, a bias towards the union. It has necessarily to be so for historical reasons, because we need a strong union. But of course, a strong union and strong states are not necessarily incompatible. As Palkiwala very rightly said long ago, what we need and what the Constitution envisages is a strong union of strong states. Having said that, the federal nature of the Constitution speaks of distribution of powers. So you have the powers that are given to the union, powers that are given to the states. Then you have a third list, the concurrent list, where both could exercise legislative powers. And of course, the union overriding power. The executive power is coextensive with the legislative power, except where it is otherwise provided by law or the Constitution. So this is all right in the case of the union and the states. You also have centrally administered territories. That is what we call the union territories. Union territories, of course, are generally, the whole concept of a union territory is that it has no legislature, it is administered by the center. Call them lieutenant governors, call them administrators appointed by the president. But the Constitution also introduced Article 239A, which spoke of giving powers to the union territory, in the sense that could be a legislature for the union territory set up by law, and those powers are prescribed by the law. In 1991, there was a step further. You had Article 239 AA, which is a special provision which conferred a special status on Delhi. It was named the National Capital Territory of Delhi, and certain special provisions were incorporated into the constitution, which made the NCT sui generis. It is a union territory in one sense. It is definitely not a full-fledged state. The point is that you have a council of ministers, you have a legislature, and a council of ministers responsible to the legislature. But the chief minister and the council of ministers are not appointed by the governor or the lieutenant governor. They are appointed by the president. The lieutenant governor is bound to act on the advice of the council of ministers, except where it is specifically otherwise demarcated, unlike the general position in the center in the states. The legislative powers of the Delhi legislature extends to subjects in list 2, that is the state list, except entries 1, 2 and 18, public order, police and land, and where the executive power is coextensive with the legislative. That is where the legislature is competent to enact laws on subjects in list 2, excluding entries 1, 2 and 18. The governor, the lieutenant governor, is bound to act on the aid and advice of the council of ministers. Of course, there is again a special provision that in case of any difference or necessity, he could refer the question to the president for resolving. And in that case, he would have to abide by the decision of the president. Now, all this came up 5 years ago in the case of NCT of Delhi versus Union of India, where a constitution bench on 4th July 2018 pronounced upon these provisions. The essentials of a parliamentary system of government expounded earlier in Ram Javaya and Samsher Singh, which I referred to, were reiterated, and the importance of collective responsibility was highlighted. Collective responsibility and aid and advice are mutually reinforcing principles. They affirm and enhance the democratic values on which the cabinet form of government is founded. Analyzing the constitutional provisions and the transaction of business rules 1993 for Delhi, it was laid down Delhi is in a class by itself with a special status, but it continues to be a union territory governed by Part 8. It's not a state within the meaning of Article 246 and Part 6. The government envisaged for Delhi is also based on the Westminster model and subject to the express provisions of what I mentioned, 239 AA and 239 AB. Delhi has a legislative assembly, but certain subjects are expressly reserved for parliament. The executive power is coextensive with legislative powers, and in areas where the legislature can pass laws, the governor is bound to act on the aid and advice of the government. Regarding the proviso to 239 AA4, it was held that it is not every matter which the lieutenant governor can refer to the president. The proviso should preserve the national concerns underlying the conferment of such power, and the exercise of that power must not destroy the essential democratic values which 239 AA recognizes. The proviso is more in the nature of an exception, and the lieutenant governor And the rule is that he acts on the advice of the ministry. What are the matters that are to be referred to cannot be exhaustively listed, but it's to be noted that they are only exception. Now, that judgment governs the field. The occasion for the present judgment, very broadly speaking, arose on the issue as to who would control services in the National Capital Territory, as the government of New Delhi, of the National Capital of Delhi, or the Lieutenant Governor acting on behalf of the central government. So it was a very narrow area that had to be addressed in this case. The larger canvas was already painted 5 years ago, and only the certain loose ends, if at all, were to be tied up. As I said, the Legislative Assembly has power to make laws with respect to matters in the state list and the concurrent list, except as regards public order, police, and land. And the legislative power and executive power extends to all subjects in list 2 and 3, except when they are specifically excluded. But this is important. Unlike in the case of states, Parliament has power to make laws with respect to all subjects in list 2 and 3 for the national capital. The issues were basically 2 or 3 phrases in 239 AA3. It said, insofar as any such matter is applicable to union territories, and the other expression was subject to the provisions of this constitution. Now, these are what really fell for interpretation and enunciation to clarify and rule upon the position as to in whose control the services are vested. It's interesting, as the court pointed out, list 2 is state list. It doesn't speak of union territories. But then Delhi has been conferred with the legislative assembly. Legislative powers are conferred on the assembly, and therefore the use of the expression state in various entries in list 2 does not detract from or divest the jurisdiction of the Delhi legislature to enact laws with respect to those subjects, except of course those which are expressly excluded. That's entries 1, 2, and 18. To repeat that again, public order, police, and land. The expression insofar as any such matter is applicable to the union territories, it was held, is not one of exclusion, but it is inclusive. Nor can it be considered to be so irrespective of the subject to the context. If it is if it is interpreted as excluding, then it will defeat the very purpose of granting a special status to NCTD, as 239 AA contemplates. Now, the 1991 Constitution Amendment, which brought about this, introduced a fresh dimension to the governance of union territories. We can't overlook that intention. Matters which are within the legislative competence of the legislature, the governor, the lieutenant governor, has to act according to the aid and advice of the ministry. He may act in his discretion only where matters are beyond the legislative powers of the legislature and where the president has delegated those powers to him, and in matters which by law require him to act in his discretion, or where he is exercising quasi-judicial powers. Now, coming specifically to the question of services, the court noticed the underpinnings of a democratic governance and spoke of a triple chain of command and accountability. And what is the position of civil servants in a constitutional democracy, in a cabinet form of government? It cannot be that, civil servants occupy a very important position. It is they who really run the administration and implement the policies and decisions of the government. They are expected to be apolitical, but they can never be unaccountable or non-accountable. The essential character of the Indian Federation is to place the nation as a whole under the control of the union government, while the regional or federal units are allowed to exercise their exclusive power within their legislative and coextensive executive and administrative spheres. Now, it is important that the power of administration, that the real power, must reside in the elected arm of the state, subject, of course, to whatever the Constitution prescribes. And therefore, the triple chain of command and accountability envisages that the civil servants are accountable to the ministers, the political executive. The ministers, the political executive, is accountable to the legislature. The legislature is accountable to the electorate, we the people. Therefore, vicariously, the civil servants are also accountable to the people, and this underpins the essential democratic principle on which basis the whole constitution and the polity is founded. And therefore, the elected government of New Delhi, or the capital territory of Delhi, has to have control over the services. The civil servants must be accountable to the government, where the mere use of the word state in the entries would not exclude the legislative competence of the union territory, because if that were so, that logic would lead to very absurd results. Then list 2 itself is state list. It's not union territory list. And therefore, no union territory which has a legislature would have any field of legislation, which means their legislative powers could never be exercised. Such would never be the intention. You don't create a body and clothe them with, and purport to clothe them with powers, which powers can never be exercised. Now, services is entry 41 of list 2, which falls under the state list. And therefore, services would come within the legislative competence of the union territory, the national capital, except, of course, because it is expressly excluded, except those subjects regarding public order, police, and land. Since these subjects are expressly excluded, even services pertaining to these would not be within the legislative competence of the national capital of Delhi, and therefore not within its executive power as well, and therefore control over services relating to these three would not vest in the government of Delhi, but would be with the union government. I think the judgment has proceeded on very neat, step by step reason and logic. In conclusion, the judgment held there does not exist a homogeneous class of union territories with the similar governance structures. National Capital Territory of Delhi is not like other union territories. It is a special status, unique status. The Assembly of the National Capital has competence over entries in both state and concurrent list except those expressly excluded, which I have mentioned. Parliament has legislative competence over all matters in list 2 and 3, that's the state list and concurrent list as far as NCTD is concerned. The executive power is coextensive with the legislative power. The Union of India has executive power over the 3 entries in list 2, regarding which NCTD has no legislative power. That is again public order, police and land. The phrase insofar as any such matter applicable to union territories cannot be read to further exclude the legislative power of the NCTD over entries in list 2 or 3 over and above what is expressly excluded, that's entries 1, 2 and 18. Similarly, the subject with a reference, the subject to the provisions of the Constitution again is not restrictive. The legislative power of NCTD is to be guided by these broader principles that the Constitution envisages. And therefore, NCTD has legislative and executive power over services in entry 41, except those expressly excluded. This is the broad purport and substance of the latest judgment, which I'm sure would strengthen the democratic fabric, would strengthen the federal principle, and is with great respect fully in consonance with the constitutional provisions and their intent. Thank you.
Wonderful, sir. Wonderful. That's off to you. The way you have narrated, because this would make it very clear to every citizen what is constitution and the provisions. Yes, sir. Please.
Voice is slightly, if you could slightly increase your volume. I can hear, but not.
Is it clear now? Is it
Yeah,
clear
yeah,
now?
yes, 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 yes.
Yeah, yeah. Sir. Lastly, the connoisseur of law, or the law-abiding citizens, or we the people, the way you have very neatly brought, stating legislature is elected by the people. That is mean we the people are the boss, not the MLAs or MPs or those IAS or IPS, whoever is. There should not be any tussle when it comes to the implementation of the policies or decisions in regards to public utilities, welfare and development, because they are all answerable to we the people. When such is the case, the demarcated powers, no one should transgress at the cost of functional, or we say representative democracy as envisaged in the provisions of our constitution. I'll just show certain things and then take one or two comments from our honorable guest. I'll try to show some audio visual as usual on DRTSPR channels. Delhi government wins Supreme Court battle with center, gets control over services. Supreme Court in a unanimous judgment ruled in favor of the elected government and said it will have power on all services except law and order and land, as has been very clearly explained by our wonderful guest 1, 2, and 18. It is the same. Just trying to show you, many have been, at times they are poking politically also. That is not at all good. तेरा बाप ये तेरा बाप तेरे बापों का हिसाब है लच्छा बाप है बेहिसाब है ला इलाज है तेरा शराब है नॉक नॉक तेरा बाप है ये तेरा बाप है तेरे बापों का हिसाब है लच्छा बाप है See, such type of things, mocking at such a wonderful decision by the Supreme Court of India. Don't forget 1, 2, and 18, not under the legislative power of the Delhi Assembly, as the rightly public order, police, and land. They should understand, all those who are trying to poke at the Constitution. Here is the Supreme Court of India 1950. I am quoting from the official site. Delhi government versus LG, Lieutenant Governor. All services, IAS officers in Delhi except land, police, law and order to be under control of Delhi government, not central government. Supreme Court. This constitutional bench said that it has to be ensured that the governance of states is not taken over by the central government. The Supreme Court today, that means on yesterday, May 11th, ruled unanimously in favor of Delhi government on the issue of who controls the bureaucracy in the national capital. The five-judge constitutional bench, headed by Chief Justice of India D.Y. Chandrachud, held that the legislature has control over bureaucrats in administration of services except in areas outside the legislative powers of the National Capital Territory, NCT. And I'll show you the last one, and then this is our this thing poster for today. The Delhi Judgement, a Perspective. That's the title. Again, immediately, Aam Aadmi Party alleges centre defying verdict on control over bureaucrats. The Delhi government has approached Supreme Court alleging that the centre is defying the constitutional bench order on the control over bureaucrats the very next day. And they have sent some other things, but we don't want to mock at a wonderful uh, decision arrived by the constitutional bench of the Supreme Court. So I'll just take some comments. So how do you look at the scenario, sir, wherein the very next day, Aam Aadmi Party, led by Delhi.
What is it that has happened, and what is it? What is the allegation? God knows, I don't know. Please.
The allegation is, in spite of the constitutional bench passing the orders on who should reign in the services
Yeah,
of
that's right.
bureaucrats,
Yeah, yeah.
they are not being allowed. Center is defying. The very next day, I don't even understand.
No, no. What is that? This is a very vague, abstract judgment. This is like saying the sun is shining bright. Yes. So what? What is it? What is the concrete thing?
They say,
I mean,
they say,
isn't it?
other
To
than
say, 1 minute, sir.
public
To
order,
say that
yeah,
someone is defying is okay. I mean, I'm not saying anyone should defy, but you must explain what the defiance is. Otherwise, how do we react to it?
yeah. I hope, Mr.
Isn't
Kejriwal,
it?
you are listening. What is that being defied by the central government?
Ah,
Public order, police, and land doesn't come under
or
your purview,
outside, or outside
outside
the
your
Delhi
purview.
government.
And you are Aam Aadmi Kejriwal fan and all. They are releasing such type of audio video effect. They wherein you are walking like a Maharaja, police, everyone. This type of things you should stop in the interest of public, because
That's
such a
right.
wonderful order, very clear. This order is as explained by our wonderful guest, and this order also should make the conditions, I mean the conditionalities existing between the constitutional bodies very clear and very straight, so that they sit down to the business of serving the people, both the constitutional, whether it is governor or the legislature. They should not be seen doing something which would jeopardize or paralyze the governance. In turn, it would be nothing but a big setback for people
and hurt
participating in
public interest.
constitutional democracy. Like again, we say we the people, as very clearly brought out by Vidi Sudhish Pai, everyone is answerable to us, we the people, because we are the constitution. They are just public servants, whether it is elected legislature, parliament, or those electing the president and then president appointing governors. They should not, for including the IAS, IPS, all directly they are answerable to we the people. When such is the case, when people have given you, elected you, you should not be indulging in political rhetoric. Take the essence of the Supreme Court order and start functioning in a transparent and accountable way. The same thing should be replicated right from Panchayat. You should not forget the Chief Minister's legislature. The same type of freedom through amendments in the form of 73 and 74 applies to Gram Panchayats and municipalities also. They too have freedom to work like you, as the Supreme Court has ordered.
Within their sphere.
Within their sphere, everyone should act within their sphere. They should be allowed that independence in ruling, whether the panchayats, municipalities, or municipal corporations. The legislature has to understand, the ministers have to understand, they need not poke their nose in the day-to-day administration of panchayats, municipalities, and municipal corporations. As governor should not interfere in your functions, similarly you are also not supposed. What we are trying to say is the powers are very clearly delegated. When such is the case, why this political rhetoric daily in the name of this party or that party? In doing so, you are distracting from the existing woes or problems of the people. Lot of corruption, lot of promises which go unhonored. So much the essential commodities or whatever you say, they have become very costlier. We say inflation is at a higher level. Unemployment, when it is ruling the roost. Farmers, they are not getting the right price for their produce. They are going around begging bowls. But when we as consumers go to buy, the prices are skyrocketing. Who are benefiting? Who are those hoarding instead of storing in our FCI godams? Now hoarding has become a major this thing. So in doing so, neither farmer nor consumers are happy. Transport has become very costlier in spite of the oil rates coming down. When such type of things are happening, and again, very unfortunate, even we are requesting through you, good officer, Supreme Court should take up the electoral bonds issue immediately. Otherwise it will be a lot of injustice, because those who are funding political parties, how is that we the people, they are all answerable to us? I'm using the colloquial language. How is that we the people do not have access to the information as to which corporate company, which industry is funding how much and which party? In doing so, in not allowing such type of information, this will elections can never be, say, we say it will be free and fair. The same corporates, they fund the political parties and the candidates, they win and they come back, offer lots of some freebies, but the natural resources coupled with human resources are taken away by these corporates. Such important issues are there. I only hope this landmark judgment will start leading to such type of electoral bonds issue, and the independence of Election Commission of India and the constitutional bodies, whether it is CAG, CBI, Enforcement Directorate, or otherwise, all such type of constitutional bodies should start functioning independently without interference, as is happening in between governor and the legislature. When such is the case, no one should no one should feel would be feeling sorry if the very next day this elected Delhi government starts complaining. Again, they go to the Supreme Court stating their own order, the constitutional bench order, is being defied. so vaguely they are stating. Where are they defying? How are they defying? Why are they defying? They should make it very clear to the public, because here we the people are more important, and we only hope Supreme Court judgment will be an eye opener for the forthcoming some wonderful issues wherein the people are just eagerly awaiting. Your passing comment, sir, before we say bye. Wonderful to host you once again.
Uh, there's nothing really much to add, except that this judgment is one more step to reiterate and reinforce the basis of the parliamentary form of government that the Constitution envisages, the principle of representation and accountability, and that everyone functions within the confines of his authority as envisaged, as laid down in the Constitution. Thank you.
Wonderful, wonderful. And I request our honorable guest to be regular, or else as and when he has some time to throw light on all such constitutional things wherein we are not prejudiced. Every citizen should understand the constitution. Only then only then you will be able to elect a proper representative who will serve you, right from panchayat to Lok Sabha, even Election Commission of India. Our petition is there. When we ask the qualifications issue with all evidences, still Election Commission of India till now has not come forward or forthright. Such type of issues also should be taken over by Supreme Court in larger public interest, where we, the people of India, the Constitution reigns supreme. Thank you very much, sir. Do support
Thank
DRTSPR
you.
channel,
Thank
Citizen
you. Namaskar.
DRTSPR channel, and Environment People DRTSPR channel. Thank you. Thank you very much, sir. Good night.
Namaskar.